It's not in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And today we're taking an in-depth look at the three versions of the Ali Act. We're going to look at the Muhammad Ali Professional Boxing Act, the Muhammad Ali Expansion Act, and the most recent iteration that was introduced to Congress this year but has not been passed, the Muhammad Ali American Boxing Revival Act. We discuss why they were formed, what their intended purpose was, what protections they offer, who they benefit, and more. It's our most detailed, easy to understand explainer built for those that want a crash course in boxing legislature. Now, this holiday episode is completely free, but we do urge you to please pick up a paid subscription as it helps us keep the lights on, and when we do have paywalled content, it helps you have access to the stuff behind the paywall. Now, John, how the heck are you?
Good. Getting ready for the holidays here, and very impressed with how you can do that introduction on the fly like that, and sound so professional. I cannot do that. I'm sure people listening right now can hear me stuttering through just my response to you. How unprofessional I am compared to you. It's a bad comparison right here.
Well, I did have some notes, and then I added to those notes that my partner here, you, has provided for me, and I just added some extra stuff to it.
Oh, look at that. You're cheating, in other words. Cheating with your notes. Okay, I feel a little better on that front then.
I did cheat. Now, we've got a big episode here, so we should dive right in and get it going. So the first question: why are we going over the Ali Act?
Well, I mean, the most obvious reason is probably because it's a holiday week and we are not sure what our schedules are. So we were like, we should do something that we can drop into the week, and also something in depth enough that people that maybe they don't want to talk to their families during the holiday can listen to multiple times. Gives them a reason to exit the room from the uncle and listen to the show. Also, I've noticed a lot of people lately, mostly in combat sports, sadly, including the media members that cover the boxing world, boxing combat sports, that they don't seem to understand the original bill or what the new bill is proposing. So this is primarily to help a lot of people get a better understanding of the bills. And I saw a need for that. And now we have covered all the Ali Act, all of it a lot before. So we did deep dives in the Ali Act. I remember I did a deep dive with you. When the new bill was introduced, we discussed it and went over it. We had on Pat English. We had on Kurt Emhoff, twice Kurt Emhoff. We had on Lou DiBella and Rob Macy. And all those guys are experts in their fields and just really knowledgeable people in the world of combat sports, boxing and MMA with Rob Macy. And so we had them to discuss aspects of the bill extensively. And I think that it's kind of a problem, too, because people that want to get up to speed, people that maybe need a refresher or don't understand it, that's a lot of material. So on top of needing an episode for the week, we thought, why don't we do kind of an in-depth, taking all the knowledge that I've gathered myself, that we've learned from these people, that I've learned from, because I have read just pages upon pages, the congressional hearings on the previous legislation. Why don't we take that and put it in one spot to make it as easy as possible for people to understand what the Ali Act does and what this new bill, this new version of the Ali Act possibly could do.
Can you give us some background as for why people back then felt the need to pass special federal legislation for boxing? And by back then, I'm talking about pre-1990.
Well, leading up to the Ali Act, so if people not aware, the original bill, the Muhammad Ali Professional Boxing Amendment Act, amended a previous bill. That bill was passed. The Ali Act was passed in the year 2000, became legislation. It amended a previous bill that came out in 1996 called the Professional Boxing Safety Act. And it was a long process, basically several decades worth of process of getting there. At the time, and people might not be aware of that, but if you go back in the 90s, boxing was in many ways much worse than what we have today. Now, we can look at today and say, oh my God, it's terrible. It's not on TV. It's having all these problems. But there was just such abuse of fighters back then, such corruption. Coming out of the 50s and 60s, they did these hearings in Congress that started. The Estes Kefauver had these hearings that investigated the antitrust implications of the bill, boxing, what was going on with monopoly, but also the criminal roots that had reached into boxing, that the mafia was so involved, that there's so much corruption. And so over the decades, Congress has always looked at boxing and discussed doing something to help fix it, because they were, in many ways, they were waiting for the stakeholders to boxing to do something on their own. And they've said that several times. If you go through the congressional hearings just pick one out of any decade, there'll be someone talking about how we are waiting for boxing to get their house in order on themselves, to fix this themselves. They seem incapable of doing it. And so Congress eventually stepped in, first in 96, to address issues about boxers' health and safety with the Professional Boxer Safety Act. And then they decided to move on to the parts that impacted their economic well-being. And they decided to do that because there had been a long history, as they gathered information of people abusing boxers, starting with, we can go back in the 50s with the international, even before them, but the most famous is starting with the International Boxing Club, which was found to be a monopoly by the U.S. government in an antitrust case and was broken up. And that launched the Kefauver investigations in the 60s. And then in continued practices that were viewed as anti-competitive, monopolistic. And so you can see that in the findings of the legislation, where they said in the findings, professional boxing differs from other major interstate professional sports industries in the United States in that it operates without any private sector association, league, or centralized industry organized to establish uniform and appropriate business practices and ethical standards. So that's what we talked about. They just can't police themselves. It also argues that state officials are the proper regulators of professional boxing events and must protect the welfare of professional boxers and serve the public interest by closely supervising boxing activity in their jurisdiction. I should note, several times in the legislative history, you will see them also bring up that the state officials are also incapable of supervising boxing, because the major players can play the states against each other, which we've discussed multiple times in the show. The third finding was promoters who engage in illegal, coercive, or unethical business practices can take advantage of the lack of equitable business standards in the sport by holding boxing events in states with weaker regulatory oversight. You see, as a note there. 4, the sanctioning organizations, which have proliferated in the boxing industry, have not established credible and objective criteria to rate professional boxers and operate with virtually no industry or public oversight. Their ratings are susceptible to manipulation and have deprived boxers of fair opportunities. 5, open competition in the professional boxing industry has been significantly interfered with by restrictive and anti-competitive business practices of certain promoters and sanctioning bodies to the detriment of athletes and the ticket buying public. And number 6, it is necessary and appropriate to establish national contracting reforms to protect professional boxers and prevent exploitive business practices, and to require enhanced financial disclosure to state athletic commissions to improve the public oversight of the sport. So that was their findings, and that was because that was all the problems they saw before. And I want to highlight one thing before we move on, which is missed by a lot of people when they look at like the disclosure aspects or other parts of the Ali Act or in boxing, is this bill in many ways is an antitrust bill, is an anti-monopoly bill. Remember, the original investigation started in the Kefauver commissions or committee meetings back in the 60s, which were part of the Antitrust and Monopoly Department, which looked at anti-competitive practices in boxing. And they reference those the Kefauver meetings a lot. They also reference the fact that the anti-competitive behavior by promoters allows them to monopolize weight divisions in boxing currently. And so when they say anti-competitive, when they talk about it being a pro-competitive bit, they're trying to create more competition. Competition law is another word for monopoly law, antitrust law. And so people should remember that one of the intents of the Ali Act was to create more competition by preventing people from abusing it by engaging in restraints in trade. So that's one thing to really keep in mind. And that's the conditions they were at was that certain promoters, namely Don King, but also others, were engaging in practices that were preventing boxers from properly having being able to participate in a very competitive market. And they saw through this was a chance to tackle that and other problems in boxing at the time.
What was the full intent of the Ali Act?
Well, if we go into the intent, that's the background, the findings, and the purpose is laid out in the purpose of the amendment, which they put at the very top of the amendment when they passed it. The purpose of this act, the Muhammad Ali Professional Boxing Act, are one, to protect the rights and welfare of professional boxers as an interstate basis by preventing certain exploitive, oppressive, and unethical business practices. Two, to assert state boxing commissions in their to assist state boxing commissions in their effort to provide more effective public oversight of the sport. And three, to promote honorable competition in professional boxing and enhance the overall integrity of the industry. Now, the first one is pretty important, to protect the rights and welfare. It should be known on an interstate basis. The reason they say on an interstate basis is as soon as you have interstate trade, it's federal, right? If it's state trade, there's no federal oversight to that. And so that's why the federal government, they rule that boxing is interstate commerce in the U.S. versus International Boxing Club of New York case. And because of that, the Sherman Act, i.e. antitrust laws in the United States, applied to boxing.
Can you give us a quick summary of what the Ali Act amendment did?
Well, the amendment, again, amends the Professional Boxing Safety Act. What it did is it added a bunch of protections to boxers. It added a contract requirement. It added a protection from coercive contracts. It added requirements to sanctioning organizations regarding the ratings. It required disclosure from promoters to boxers and commissioners by sanctioning organizations, judges, and referees. And it also forbid various conflicts of interest. So that's what it did. But as we'll note, it probably is not as effective as it sounds. All those are great. All those sounds like things you'd love to have as protections for boxers. But the implementation of these protections provisions has not worked out the way I'm sure they hoped it would.
Let's go into more detail on some of the sections of the bill. What were the new contract requirements?
Well, in criminal code, for the U.S. criminal code, I'm going to use that. So when people are following along, this is the way it's written. So when I repeat what's the passage from the Ali Act, it's the way it's actually reads in law. If you look at the Ali Act amendment, it just shows how it's supposed to amend the Professional Boxing Safety Act. So often it'll just have one or two modifications of the previous bill. So here I'm reading how it reads in the criminal code, the U.S. code. So 6307A is a contract requirements, and it said within 2 years after May 26, 2000, after the bill was signed, the ABC, the Association of Boxing Commissions, was supposed to develop and approve by a vote of no less than half new contract reforms. And these reforms, as I'll paraphrase, establish national contracting reforms that require contracts to be reasonable, include mutual obligations, and specify a minimum number of professional boxing matches per year. Now, that's what it's supposed to do. It actually did. They came up with these guidelines. There's a big weakness with this is these are just proposed. These are suggestions. There is really no teeth to it because the promoters, managers, anyone else using these contracts, these bout agreements for promoters, they're under really no obligation. There's no teeth to the law that says you are required to use these. These contracts are more suggestions than anything.
Explain the section about protection from coercive contracts.
Well, you listen to the show, we've had numerous people that we've talked to us about. And while it hasn't been 100% perfect, a lot of them will note that this is perhaps the most effective portion of the amendments made by the Ali Act. And this is 6307B, protection from coercive contracts. And what this does is it protects boxers from unconscionable contracts and exploitative abuses. The law was intended to curb the use of what's called coercive practices. And what that is it's requiring long contracts by limiting certain exclusive promotional rights to a maximum of 12 months. That's what the bill's supposed to do. So if I'm a promoter and I offer you a fight and you want to fight, you're a boxer or the manager of a boxer and you want to fight one of my boxers, a practice that used to be done all the time was called offering options. And so if I'm a promoter and you're another boxer and you want to fight my boxer, I cannot demand options from you. I cannot demand a long-term contract from you for the right to fight that boxer. That would be called a coercive contract. And really applied in the past with Don King and other promoters. They would do this with their champions. They'd have a fighter under contract with them that was the champion, and you wanted to fight the champion for the chance to become a champion yourself. They would say, you want a chance to fight him, you have to give us options of 3, 4, 5 fights or multi-year contracts just for the chance to fight. If you beat my guy, I will now have rights to you as a promoter for several fights afterwards. And that way, the promoter won no matter what, because whoever won the fight, they were promoting. And so that way they retain control of the championship. It also gave them a great deal of leverage in negotiations because the boxer, he wants to fight for the title and he has no real options unless he agrees to whatever that promoter demands to get that chance. So that's the coercive contract provision. Now, the thing about it, it's not, it works great in some ways, especially for the top fighters, because of two things. One is that the coercive contract provision works great when you have a top fighter fighting another top fighter, because of the independence of sanctioning organizations in boxing. You have no way to dictate to them the fight without, in other words, you have to offer a fight to move up the rankings. You have less ability to demand them sign with you ahead of time. And so that fighter, him and his manager, him and his agent can look at the contract and say, there's no way I'm going to sign this if you demand unreasonable extensions. Now, as Pat English noted, many people still put this in contracts. Don King does, but a good agent, a good manager, a good attorney will look at it and say, this is just unreasonable. We're not signing it. So that's one way to help. The other one that really helped is the mandatory requirements. On mandatory bouts in boxing, if you're not aware, the sanctioning organizations will often declare a mandatory. He's the top challenger. He's declared a mandatory. The champion has to compete against him in order to hold the title, to remain the champion. If a mandatory bout is declared, well, the promoter of the champion cannot demand any options whatsoever for that bout. The challenger automatically can get the fight without signing over any future rights. And this actually is a big win, especially for the guys at the top, which, again, as we pointed out earlier, it's a pro-competition bill. So you want to have the very top guys floating around to different promoters to create more competition in the market. But in that sense, it is very positive, as Pat English noted, as Kurt Emhoff, that it's eliminated to a great deal of that practice in the United States, the Don King practice of making boxers sign with them. And if you look through the legislative history, the one thing they noted about that was a way promoters could monopolize a weight division, because by demanding options, you had to sign with them. Eventually, you're going to have all the top boxers under contract with you, because anybody who wants to fight for the title has to agree to sign with you, that promoter, to get a chance. And then you have options on all these fighters. So you control the very tops of that division, and you have a monopoly over that weight division. And so this is probably one of the most effective parts of the Ali Act, one of the most successful parts of it. But again, it's limited somewhat to the very top fighters. But it has been at least according to many people in the boxing industry, perhaps the most effective portion of the bill.
What did the Ali Act require of sanctioning organizations?
Well, for sanctioning organizations, it made a lot of demands, and it tried to clean them up because, as it noted, there was a lot of problems with sanctioning organizations, as we noted in their findings, is that their ratings weren't objective, that there was a lot of influence by other promoters, perhaps bribery, corruption. And we know there was corruption because the FBI around this time invaded the IBF for a corruption scandal of taking bribes. And so they had all these changes they required put into the Ali Act amendment. And they included one, objective criteria. They wanted within 2 years the Associated Boxing Commissions to develop and approve a criteria, objective and consistent written criteria for the ratings of professional boxers, which they did. It's a little limited, but you can look and see what they came up with. They included there was to be an appeals process where the sanctioning organizations shall not be entitled to receive any compensation, because remember the fighters pay for the compensation for their title bouts. They pay a fee to the sanctioning organizations. They shall not receive that compensation directly or indirectly until they provide the boxers with notice that the sanctioning organizations shall, within 7 days after receiving a request from a boxer, questioning that organization's rating of the boxer. So it gave the boxer the right to appeal what the rating is. They also demanded that the sanctioning organizations give notifications of changes in the ratings. And then there was a portion on public disclosure. The Federal Trade Commission they had to file with. There is a format update they included in this because you got to remember we were going from the era of everything done by paper, letters, into the internet. And so they had some additional changes here about how you could file electronically, how you could use the internet to file. So that was the changes they were demanding of the sanctioning organizations. And it should be noted that while they had some criteria for the rankings, and Kurt Emhoff discussed how he's used the appeal process before, it is generally been considered mostly a bust. That because, again, just like the contracts, there was no true obligation to these ratings changes, to the objective ratings, which is something that's was brought up after the Ali Act was passed, brought up time and time again. How can we improve this system? The sanctioning organizations were pretty much still left to their own accords of who's going to do the voting, how they're going to arrange the rankings and ratings. And so there's very little fighters can do to challenge them, and that they are not what you consider truly objective, or even if they are objective by their standard, many people on the outside would look at it and say these are terrible ratings. And so that has continued to be a problem. And there's also the problem of corruption, which boxing continues to have. We've had court cases and stuff that suggest that certain members of sanctioning organizations are still getting paid off. And that is something, as a comparison to MMA, the big difference in boxing and MMA is boxing continues to have a degree of corruption, but part of that process is the fact that everything is separate. So you have the ability to bribe, where in MMA, everything is self-contained, and there's no point in bribing yourself if you run everything. But these sanctioning organization changes, it was high, they made a big deal originally, but I think they quickly realized that there was, these were not going to be enforced enough. These were not stringent enough, that they were not being effectively used. And so, as I noted, immediately afterwards, with additional bills were introduced later, in an attempt to amend the Ali Act more. They wanted, they wanted these rating criteria to be strict guidelines that had to be followed by the sanctioning organization instead of mere suggestions.
What does the required disclosure for promoters do?
Well, this is the one that's highlighted the most often as the biggest or the most successful portion of the Ali Act. I would argue it did something, but it's not the most important. And this is 6307E, if you're following along on the U.S. Code. And the required disclosure is, what it required is that that you had to disclose, the promoters had to disclose to boxing commissioners any compensation they received for a boxing match in I should repeat that. Let's say that before they're entitled to receive any compensation from a boxing match, they had to hand over various forms, information to the athletic commissions about the match. And so, in addition, had to disclose to the boxers. They had to disclose to the athletic commission all payments they received, gifts, and this applied not just to the revenue they were getting from the parties that were paying for the match, but they had to disclose anything that possibly could be a conflict of interest, compensation from sanctioning organizations, managers, whatever. And many of them are banned as well. You're not supposed to get those things, but you had to disclose any fees, charge, expenses. So in a weird way, they're trying to make it sure that the promoter could not take advantage of the boxer or take advantage of the commission by hiding revenues and sources like that. But they also included in a disclosure to the boxer that a promoter shall be entitled to receive, that a promoter shall not be entitled to receive any compensation directly or indirectly in connection with the boxing match until provides the boxer promotes the amount of any compensation or consideration that a promoter has contracted or received from such match, and then all fees, charges, and expenses that have been assessed by or through the promoter on the boxer pertaining to the event, and then also any reduction in a boxer's purse. So all that information, before they could get paid, the promoters supposedly, they had to disclose this to the boxer. And this is the part I think most people highlight as the biggest advantage of the Ali Act is boxers are aware of their revenue, the amount of money the promoter is making, what their events make. And that's true. And we've had people on our show discuss how this works, but it's not as perfect as I think some people on the outside think it is. For one, many states don't require this disclosure to every boxer on an event. It applies to the boxers at the top of the card who are assumed to be the ones responsible for the revenue. So those boxers in those states, they get disclosure of what the event did. Also, in this bill, the Ali Act, it doesn't state when the boxer is informed. You would like to get this information as soon as possible. Likely, you'd love to have some of the information about what the promoter is going to make before you even sign the bout to know how much money there is. But really, all it says is the promoter cannot receive compensation until he discloses to the boxer. So he could wait to the night of the fight. He could wait to after the fight if that's when he's going to get the compensation, the revenue is going to come in. And so it doesn't do the boxer much good in the negotiations for that fight if that's the case. But as Kurt Emhoff said, it's always good to have that information because it helps you on your next negotiation. Finally, the way modern TV deals work is that promoters are often given just the keys to a network. And so the promoter is given a flat sum for the year. Well, it's up to the promoter to decide how the revenue is going to be attributed to each event. So a fighter could be responsible for a lot of the revenue for that promoter, but if he divvies up each match that's on TV that you're getting the same amount of revenue from that broadcaster, that boxer's unaware when he gets the finances of how much truly he's generated. In addition, you could see that promoters could possibly do something like the rights to our rebroadcast or our highlight package to our brand gets X amount of money from this broadcaster, and our bouts are going to get Y amount, which is much lower than what really the value of those bouts are. And so there's many ways now for promoters to hide the amount of money an event is actually generating, except for, pay-per-views are hard because that's a direct payment. But if you're on a broadcast deal, especially a broadcast deal where you have contracted rights, and a promoter is a guaranteed amount of money per year, it's pretty difficult to know exactly how much your bout is generating for that promoter.
What are conflicts of interest, and what does this particular section do?
Well, the conflict of interest part is what this does is it prevents or supposedly prevents or desired to prevent basically that conflicts of interest between parties that should not be in a friendly relationship. For example, managers have a fiduciary responsibility to their boxer, right? They are there to get their boxer paid as much as possible. Promoters, by definition of the job, as definition as they define it in the legislation, have an adversarial relationship to the boxer. Their job is to generate as much money for the event, but also to make sure they get as much money from that event as possible compared to the boxer, because they make more money. Their interests are not fully aligned with the boxer, where a manager's is. And so that's a conflict of interest to try to keep a separation. And so they had several of these they enforced by law here now. One is the regulatory personnel, and that is that no member or employee of a boxing commission or person who administers and enforces state boxing laws, those people shall not receive compensation beyond a token gift amount. They shall not receive compensation from a boxing promoter. So, and it makes sense. You do not want your athletic commission officials getting paid by the boxing promoters, because then they can't really do their job. There's also a firewall they put in place between promoters and managers, because, as we explained, they have different responsibilities. A manager has a fiduciary responsibility, the promoter is adversarial. And so when they're working together, the thinking is when the two sides are working together, that's not to the benefit of the boxer, because if a manager is operating as a promoter, well, which hat is he wearing when he's dealing with the boxer? Is he looking out for the boxer to make as much money as possible, or is he thinking that the returns will be with the revenue that he gets as a promoter? Now, there are some limits to this. It was narrowed down a little bit. This firewall only applies to 10 rounds or more, the very high end of the fights, the most, the contenders and championship bouts. The reasoning at the time was that a lot of promoters, they have to put on bouts for their boxers that they have that they're representing to get them the fights, to build them up to these big fights. And so they saw that there was a need, there needed to be an exception so that promoters could continue to put on fights for the lower end boxers. I shouldn't say promoters, managers could operate as promoters so they can get their boxers the fights needed to move up in the rankings and get bigger fights. And so that they had a limit that it only impacts 10 rounds or more, which a lot of people will highlight. I should know a lot of states, athletic commissions have in their rules, state regulations, they have firewalls between promoters and managers. In many of those states, they apply to all rounds. You're just not allowed to do it. But in the Ollie Act, which is missed by a lot of people, it only impacts 10 rounds or more. And for a manager and a promoter, it also has an exception that if a boxer is operating as a promoter, there's no violation, no conflict of interest if a boxer is operating as a promoter and a manager, or either one, because they think he's looking out for his best interests there. Finally, there's the sanctioning organization also has a conflict of interest provision in the section, where the sanctioning organizations too cannot compensate. A manager cannot be compensated directly by a sanctioning organization, and the reverse. And that's to prevent corruption between the two, because their job, the sanctioning organizations, is to act as an impartial partial group with objective rankings, giving fighters an opportunity to compete for the top prizes in the sport, which are the championship belts. And so that conflict of interest section, it's been effective somewhat, because you see it challenged, and we will get into the how this is enforced in a little bit, how it's enforced. But there are often it is brought up the conflict of interest of acting as a promoter and manager. I shouldn't say often, but is occasionally brought up. A lot of the states adopted this language. They prevent promoters acting as managers, and so all those have probably benefited the sport. There's also the fact that no boxing promotion yet has introduced their own titles, and the reason they have not, it's been suggested in the past that PBC was, and as we've seen from the current legislation, some people, it seems like this has been confirmed now, that the prohibition on receipts for sanctioning organizations and the legislative history, you got to look back at the legislative history to interpret the law, because if we take it textualism, it doesn't say this. It doesn't say anything that a promoter cannot have their own titles if you go by textualism. But if you go by the interpretation, if you go by the legislative history, if you look at the intent under intentionalism of the bill, you can see that there was an interest in preventing promoters from controlling the titles. And so this firewall, on one place it's been very effective, is that no boxing promoter has attempted to create their own titles like we see in MMA.
How are the bill's provisions meant to be enforced?
Well, here's where a lot of the problems with the bill comes into play. The bill had a bunch of enforcement mechanisms. It had a federal enforcement authority behind it. The Attorney General of the United States was granted authority to pursue violations of the act. They could also do civil actions, injunctions. The Attorney General, if having reasonable cause to believe that a person is engaged in a violation, could bring civil action to the appropriate U.S. district. There were criminal penalties. The federal government could also bring criminal action against violators, certain violations, certain individuals like managers, promoters, matchmakers, licensees who knowingly violate key anti-exploitation portions or sources, sanctioning organizations portions. They could be fined up to $100,000 according to the bill. It had this in it, this penalty, $100,000 fine or imprisonment for not more than 1 year. So it had some serious punishment in it. But the problem was that, as we noticed, as we've noted since then, the Attorney General, he has not brought any charges for it. He has not brought any cases for it. There seems to be no interest on their part to enforce the bill. It's been completely forgotten by the federal authorities. And so that's a major problem with the bill. And they've noted it after the bill was passed that there was, that perhaps they could pass a future bill and they could get the Attorney General basically required in it to go after some people. The act also recognized that state commissions are the primary regulators, but granted enforcement power to the state's highest legal office to handle the interstate issues. So that runs in the same problem as the U.S. Attorney General, as the state's attorney generals do not enforce the bill. And we run into the problem that we mentioned earlier, that the athletic commissions, that the states themselves seem incapable of enforcing the bill. And a big part of that, big reason, is because enforcement could drive away the promoters, the entities that bring the most revenue to the state that they collect to run the boxing commissions anyways. And so are your attorney generals going to enforce this? Are your athletic commissions going to go ask them to enforce this against the biggest players if they're worried, if their entire interest is just getting them to bring events into their state so they can get revenue from them? And if they go after them, is that just going to mean that those major players, those major promoters, whatever, sanctioning organizations, are going to move the most lucrative fights to other states? And so that has proved to be a major problem with the bill, the enforcement mechanism. The one part that seems to work, the one part that is proven to be beneficial to boxers for the most part, is the right to private right of action. And to protect the boxer who is directly harmed, the Ali Act created an explicitly civil remedy. Boxer lawsuits: any boxer who suffered economic injury as a result of a violation of any provision of the act may bring an action in the appropriate federal or state court. They can get recovered damages from that. They can get injunctive relief. But they have the right, the explicit right in the bill to say, if a portion of the Ali Act was violated by someone against me, I can go into a court and file, federal court included, and file charges against them and get a remedy through those courts. And so the only people that enforce the bill, for the most part, have been the individual boxers. And we see there's a few cases. A lot of people like to say, oh, it's, it's never been enforced, but we do have a handful, more than a handful, I should say, of cases that have made complaints have been filed with the state and federal government. And in addition, there are numerous cases, many more cases just that, where boxers have threatened the promoter, have threatened someone, a manager, with a lawsuit under the Ali Act. And that has been settled even before they get anywhere in the system, because the promoter or the manager realizes, yes, I did violate it. I'm going to lose this case. There's no point in going forward with it. So, but the biggest problem with that is the boxer themselves has to bring the case forward. A lot of boxers do not have the means, do not have the awareness to file this. And so you see it mostly limited limited to top boxers who have the most to gain from a win. And that's the major problem with that is that there has been no enforcement at the state or federal level. And there is, though, this right to private action, or I should say a private right to action by the boxers that has been useful to a degree.
What was the impact of the bill?
That is a big question. In many ways, it was a failure. We can say that, we can come on right out and say that because it did not do what they wanted it to do, as we saw in the findings and the purpose. They had an intent for it to do, and it didn't succeed in that. We also know it's failed in many parts because after the passage of the bill, the General Accounting Office went over and studied the bill and wrote up a whole report on what additional measures should be taken, what has not been working properly. There were several hearings afterwards where John McCain introduced an amendment, a further amendment to the Professional Boxing Safety Bill, which is called the Professional Boxing Amendment Bill. We're going to get very confused when this is all done, all the amendments. But he introduced that for years afterwards, and that included, they did hearings and research for the bill about what could additional changes they could do to make it better. And it did not get the support it needed to pass. But the biggest problem, as we noted, is the bill accomplished some things, but failed at a lot. What it accomplished, I'll note what it accomplished first. It gave fighters some protections against coercive contracts. It, for the most part, in the United States, eliminated the practice that Don King had made famous in the 90s of the options, where you're required to grant options for title fights. That, for the most part, I should know, has ended in American boxing. And because America is the biggest market, you do see some of that adopted overseas because people often imitate what the Americans do, because American boxers and European boxers, when they come here and other parts of the world, the markets are not self-contained only in those countries. The biggest fighters often cross over. So that's been a general positive for fighters. There's also disclosure of compensation. It was not perfect, but it gave more information to managers and fighters than they had before. And while, again, it hasn't been perfect, they've taken advantage of that and built upon that. And so managers are generally more informed than they have been, more informed, at least up until recent days, about the type of money that's available for bouts. They've also, we had Kurt Emhoff using this as an example, there also is some right to object, to contest the rankings, and some boxers have taken advantage of that, although it has not been as effective as they hoped. So there's been some positives of the bill. And I guess the other big one is that if you believe in competition, if you're against monopoly, it has prevented from any promoter from gaining a market power, a monopoly over the industry. We haven't seen anybody come close to that. PBC was probably the closest in 2015 and 16. And we have not seen anybody take over the business like the IBC of New York. And you could make an argument that the Ollie Act plays a big part of that. And the reason is we're going to note again soon enough, is because of the separations of the sanctioning organizations and promoters, and a lot of the other provisions that create this competitive market. Promoters they just cannot take over the market. There was the discussion that PBC potentially was going to introduce their own titles. Tim Luckenoff sent a letter to the Attorney General that was made public about how this would be a violation of the Ollie Act. Now, I don't know for sure. I've heard both sides of the story, that PBC was intending it. Really, them and Waddell and Reed or Fox were really intending to come out with these titles. And I've heard others that there really was no talks, that was an exaggeration. But it doesn't matter. They didn't introduce the titles, and no one else has. And no one else has done anything where, everything is going to be a walled garden, self-contained, like you see in MMA, which is a great example, because in MMA, there's very little competition between the promoters, especially because one of them is an 800-pound gorilla that runs the entire market. So that we'd have to say is, if you believe in competition, that has been positive, has prevented any single entity from dominating boxing. Now, on the failure front, there's many. that, and namely one, that the contractual provisions that they wanted to have some protections in the contracts were never really introduced. And so people are abused all the time with their contracts. That the sanctioning organizations were not obligated to follow objective ratings. There's so many loopholes in it that they can make up the ratings as they go. And because of that, we're in the situation where we are now, where these sanctioning organizations there's just a lot of disgruntled people are just disappointed in the ratings and the contenders, and this malaise has probably impacted the sport itself. So that has proved a big failure. Another one is that the disclosure did not go far enough, so it did not give boxers the ammunition, the leverage they need to negotiate as good as to the best abilities as they could. So there's a long list of problems that it did not work as well as they hoped, but there is some success there. It does benefit boxers somewhat. You'd have to say it has created a somewhat more competitive market, but it's much more narrow in scope, much less effective than what the original supporters of the bill had hoped for. That's for sure.
What was the Muhammad Ali Expansion Act?
Well, this is interesting, kind of forgotten. This is something me and you used to talk about a lot not on this show, because this is before the show. I think on the Crickland's Corner and other podcasts, we would discuss this. And this was the bill that was introduced by Rob Macy, the MMAFA, and Mark Wayne Mullen, the now Senator Mark Wayne Mullen, into Congress, into the House of Representatives, first in the 114th Congress and then the 115th, so 2017, 2018. And what this bill sought to do was expand the Ali Act, the protections of the Muhammad Ali Professional Boxing Act, to MMA, mixed martial arts and combat sports. And that was the Muhammad Ali Expansion Act. The whole purpose was we want to expand the provisions in this bill, the sections, the protections, all this to cover MMA as well.
What changes did the Expansion Act seek to make to the Ali Act?
Well, it very little, to tell you the truth. What it did is basically just changed some terms and added a few words into it. Instead of boxer, it changed. It wanted the word boxer changed to fighter every time it appeared in the bill. And the term fighter means an individual who fights in a professional mixed martial arts competition or other professional combat sports competition. So I should say they don't want to change it. They wanted to add it. So every time it'd say boxer, it'd say boxer or fighter. That's how it was supposed to read the Ali Act from that point on. The provisions of the Professional Boxing Safety Act that are part of the Ali Act, the amendment to that, would now read, instead of anytime it said boxer, it would say boxer or fighter. They wanted to add combat sports competition instead of just bouts, and then combat sports contracts instead of boxing contracts. So that's basically it. Instead of boxing, they wanted to add mixed martial arts. So that was the only changes they really want, is so that all the provisions, all the sections of the Ali Act would apply to mixed martial arts fighters specifically, but also additionally, some of them would apply to other combat sports athletes like, professional jiu-jitsu and kickboxing as well. The only other additional change they made is, instead of where it said 10 rounds or less, I can't remember if it said 3 rounds or 5 rounds, but basically they noted that there's a difference in rounds in MMA compared to boxing.
What was the intent of the changes?
Well, this is again where it gets interesting, and people pay attention to our show. This is probably not surprising, but I think a lot of people would look at that and say, well, if the Ali Act doesn't work, what do these changes mean, and why was the UFC so adamant against this bill? It's because these changes actually would have profound impacts. Well, one is the fighters would now have the protections of the Ali Act, so they could do stuff like the right to private action. So they could, if they wanted to sue for violations, they can go to federal court. Any violation of this bill, MMA fighters could do that as well. They'd also have disclosure. MMA fighters would have the ability to ask the promoter, disclose the compensation you are receiving for this bout. And so I can negotiate in the future more informed. And so those would be very helpful. But I think the biggest ones are the ones that, are not on the surface. These are the ones you have to really delve into the bill, delve into the implications. And the first one is what we mentioned, is that would the MMA promoters be able to own their own titles? Now, the Ali Act doesn't come out and say that MMA promoters or promoters in boxing, whatever, cannot have their own titles. It just says that sanctioned organizations can't be compensated by the promoters. But again, if you go through the legislative history, it explicitly says this several times. It discusses how promoters use the titles. First, you go back to the International Boxing Club of New York case, which is the foundation of all this, that the promoter there had the champions signed to contracts, had the top contender signed to long-term contracts. And so if you wanted to fight for the title, which that case noted, championship bouts generated more revenue, and the fighters could therefore make more money. If you wanted to fight for the championship, then you had to sign a long-term exclusive agreement with the International Boxing Club. And that gave them a monopoly over boxing at the time. Then in the legislative history of the Ali Act, they discuss how promoters like Don King, others use the options, the coercive contract provisions to demand fighters sign with them if they own the titles. And that would, to long-term agreements, and that would trap them with that promoter and give them effectively a monopoly over their weight class. And so as you look through this, and I wrote an article, and people want, they can go back and look at that article about, I believe it's called What Would Amending the Ali Act Mean for Boxing, where I go through why this interpretation is probably the correct one. So I recommend everybody to look up that article, and because I go through the entire legislative history, and I go through all the examples through that history of why they do not want promoters controlling the titles. So I think that interpretation be correct. And I think the evidence that this interpretation is correct, that Rob Macy, one of the guys that crafted this, that he has been right, and that promoters under the Ali Act cannot have their own title, is because, one, the UFC opposed this bill, but two, the new bill that they introduce, they are going after titles, right? They are making sure that they can have control of titles, which we will discuss in a minute. And so that seems to suggest that this is the correct interpretation, that promoters under the Ali Act can't have their own title. And so that would be a big change at the time in the world of MMA, where not just the UFC, but PFL and the other promoters own their own titles, to say that that is a violation, that is a restraint of trade. You using your title as a means to coerce fighters to sign with you. You cannot have that, or they might be allowed to have a title, but there would have to be some drastic change to how it would be used, or how it could be, the contractual provisions would be. But that would be a massive impact to MMA, and you can see now why it was strongly opposed by the UFC. The additional one that's even less acknowledged, less discussed, is the description, the definitions of certain actors in boxing under the Ali Act would now apply to MMA. And those are a manager. If you look up the definition under the Professional Boxing Safety Act, what are the definitions of these terms? A manager, the term manager means a person who receives compensation for services as an agent or representative of a boxer. Well, that doesn't sell as much, just means they receive compensation. And then a promoter, the term promoter means the person primarily responsible for organizing, promoting, and producing a professional boxing match. Okay, well, those are pretty loose terms. But again, if you go back in the legislative history, if you go back into how these descriptions were used in the crafting of this bill, it becomes questionable if MMA business practices could be used or applied, if the UFC could operate the way they have under the Ali Act, and can you just bring the UFC model to boxing? Because promoters are expected to handle just the event, the bout, right? A manager has a job to represent the fighter, and this is the part I think they'd run into problems, the UFC, if the Ali Act was expanded to MMA. The UFC right now requires fighters to sign deals with them where they give them merchandise rights agreements and image rights. Now, I'm pretty sure under the Ali Act, no promoter would have any problem with the terms the UFC has for their event merchant rights and agreements. We just had a recent case with, I cannot remember the fighter's name last weekend. You can remind me, Stephanie?
Shamrock,
yes, that he is selling off. He's going to auction off his gear to a wealthy Saudi Arabian or someone else, Gulf person. I think I can't remember who he asked for.
Qataris.
But the UFC, Qatari. But the UFC has a deal. What they do often is, I was surprised by this because the UFC usually collects the equipment at the end of the fight, and then puts it up for sale as collectibles. A lot of people aren't aware of that. The UFC requires fighters to sign a bunch of signatures, and they sell this merchandise with the fighter's name, all that on it at the event. The fighter gets no cut of that. And so there's a lot of the UFC has, they sell T-shirts with the fighters. The fighter at the event, the fighter gets no cut. Now, a boxing promoter, I think, could do the same thing under the way the legislation's written, because that is the bout. They are holding the bout that is involved with the match itself. It falls under the umbrella. Now, this is where they get into trouble. The UFC also signs image rights agreements where they have the right to sell that fighter's image to video games, for commercials, for products outside the fight. They are no longer selling the fight itself. They are now, in many ways, operating as a manager, right? Because they are out negotiating deals involving the fighter's images, involving the fighter's licensing rights, things that are beyond the scope of what traditionally a promoter would do. And so I think that was also a big concern of the UFC, was if the Ali Act was expanded to cover MMA, could this be challenged under the Ali Act, the fact that we have these licensing agreements with fighters outside the bout, outside the event? And I know we've had Rob Macy talk about this on the show, and he's talked to other places. This is an avenue I think he would explore, and so the UFC was probably concerned about that. And and I want to note he seems to have been right about the titles. I will note too, I was independently right as well. I thought of this. I also came to the conclusion that the titles under the Ali Act, promoters cannot have their own titles. But you can imagine how big that change would be to the world of MMA if promoters could no longer have their own titles, and a lot of these sponsorship deals, merch agreements, and image right deals made the promoter a manager, made the UFC a manager, which would be a violation of the firewall between promoters and managers.
Now, give us a quick summary of what the Muhammad Ali American Boxing Revival Act is, and remind everyone who TKO is and what branches they control, because we were just talking about the UFC and how hard they fought against the Expansion Act.
Well, we should note Endeavor, their parent company too, fought at the time. Endeavor, who owned the UFC at the time, also fought this Expansion Act. Now, the new UFC is now part of a new company called TKO. TKO is the parent company of the UFC, the WWE, and a new entity called Zuffa Boxing. And that's where this Muhammad Ali American Boxing Revival Act comes in, because the act is obviously, it's obviously, I don't want to say directly written, but it probably is written by TKO. TKO is the one helping introduce it. They're the ones that want to see this bill introduced. And it's pretty obvious because they're the ones that mentioned the possibility of this before it entered anybody's radar. And so I think it's proper to call this the Ari Act after Ari Emanuel, as some have sardonically named it. And so what the bill does, what this is a bill which they claim does not change the Ali Act at all, which makes it strange why you call it the Muhammad Ali, put the name in the bill. But what this bill supposedly does, according to them, it introduces an alternative system to boxing to help revive it. This alternative system would allow boxers to operate in something much more like a UFC model, which they like to cite has had an amazing amount of growth and explosive growth. And so they were trying to bring that to boxing. And so that's the Muhammad Ali American Revival Act, is a bill that addresses some financial parts of a fighter's career, and addresses low purses, addresses some medical care, but also introduces a whole new concept called Unified Boxing Organization, which lets a whole alternative system to boxing operate.
What are the additions that it makes to the boxing industry standards?
Yeah, well, this is there's several parts of it. There's a UBO portion, and then there's other amendments to previous sections of the Professional Boxing Safety Act. But the boxing industry standards, it provides a minimum. This applies to all promoters, I should note. So this is the portion of the bill applies to everyone in boxing. For a promoter in boxing, this applies to you. You have to provide boxers that fight under you a minimum of $25,000 in medical coverage for any injuries sustained in the match, which is higher than many states currently have. It's lower than New York, though. I think it's also lower than California in the other big states, but that's the minimum now of medical coverage for injuries sustained in the match if this bill passes. And also they have to do a minimum payment to boxers. A promoter or unified boxing organization, which we'll get in the description in a little bit, shall pay a minimum of $150 to each boxer for each round in a match in which the boxer participates. And so 4-round minimums are the minimum amount of rounds the boxer participates in. So there's a $600 minimum for boxers now. And so that's the two new portions of the boxing industry standards.
What about the additions to the Professional Boxing Safety Act section of referees and judges?
Well, this one is no person may arrange, promote, organize, produce, or fight in a professional boxing match unless all referees and judges participating in the match have been certified and approved by either the Boxing Commission responsible for it or the Association for Boxing Commissions. And then the other part of the amendment, the other portion of that section 16 is the amendments made in section 4A of the Muhammad Ali American Boxing Act shall take effect 30 days after the date of the enactment of such act. So in other words, when this bill passes, if it passes, a lot of us are leaning towards it'll probably will, but if it passes and gets signed into law, unlike the original Ali Act, where it was 2 years afterwards, did the provisions of the act go into effect, this is 30 days. So very quickly would the Ali Act go into effect if the bill is signed into law.
Do you think these additions and changes are good?
Well, I have no problem with these changes. $25,000 minimum is probably good. A purse minimum, $150. Both those eliminate probably the worst of the promoters, the guys putting on basically bum fights and bars and stuff. If you ever listen to Kurt Emhoff's Boxing Esquire podcast, he had Larry Goldberg on recently, Boxing Insider, and he talked about how this is, he's all for this, that we need more standards for a lot of the boxers, that a lot of these states are just way below New York, California, New Jersey, and Nevada standards. So that's not bad. Now, the $150 a round, if you look at the amount that is disclosed by states already, the vast majority of fighters get more than $150 a round, at least on paper. Now, as we know a lot of fighters don't really get what they're paid at the low end. There's a lot of stuff involved where they have to sell tickets. It's, they're on commission, stuff like that. I see nothing in this bill would change that, but it would help some fighters who are at the very bottom getting paid almost nothing to fight. They would have to get paid something. And it probably is beneficial to get rid of those promoters that are basically putting on, like I said, bum fights. So I'm all for those. Those two are good. And I actually like, too, that about the referees and judges, that instead of letting the sanctioning organizations name the referee and judges, the athletic commission should, because I think it's too ripe for corruption and just the appearance of corruption, but also corruption itself, to let the sanctioning organizations name those officials. So all these I think those three are great additions. I have no problem with those. The ones we've talked about so far that I have some qualms about, I guess more than qualms, is the fact that the bill goes into effect only 30 days after signing. So I think that's a giveaway that this is a rush job, that they are trying to get this through and out the door so that they can apply it to their Zuffa boxing when it launches next year.
And now we get to the Trojan horse. What is a UBO?
Well, according to the bill, if you look up a UBO, which is known as a Unified Boxing Organization, is an alternative system for compliance with the requirements of this act, the act being the Muhammad Ali Professional Boxing Act. It's a unified boxing organization, shall be deemed to be in compliance with the requirements of the Act if the UBO meets the conditions of this section. So they have a bunch of requirements. And so a UBO is basically a system where the what used to be we call a promoter can wear many hats. No longer is there conflict of interest between a promoter and a sanctioning organization, or even I would argue between a promoter and a manager under the previous definitions. If a UBO is in effect, because a UBO is a self-contained organization that offers, like a league, as they say it, that is able to offer its own titles, fights, and have its own belts and its own ratings. And so, simplest way to say it's basically allowing the UFC MMA model into boxing.
What are all the requirements in order to be a UBO?
Well, they have a long list of requirements. You have to offer enhanced medical exams. So all the boxers have to undergo comprehensive medical exams annually and before their first fight, which includes like physical eye exam, HIV, hepatitis, just a long list. They have to do advanced testing. They're required to have brain MRI to check for abnormalities. They need additional exams if you're over 40. They require health insurance. Boxers have to have access to a minimum health insurance coverage for injuries sustained during a bout, as well as training of a minimum of $25,000. So, and that's in addition to the $25,000 for the injuries they could suffer, the previous health insurance that covered during the bouts themselves. In addition, they're required to have the following at events. They have to have increased ambulance presence. They have to have 2 ambulances. They need more ringside physicians at each event. They have to have an anti-doping program. The UBO must implement comprehensive anti-testing program, which it doesn't really specify the testing program, interesting enough. And Pat English has talked about this, how in many ways this could potentially water down the requirements of the doping that a lot of these sanctioning organizations already have in place. It has an anti-betting policy just in time for the gambling scandals. It has no fees for the boxers. A UBO cannot charge boxers for the fees for placement on rankings or the right to compete in championship matches. In other words, they cannot charge the fees that sanctioning organizations do to compete with their titles. And they have to have public disclosure. So sanctioning organizations have to file their bylaws, rating criteria, stuff like that. But the UBO doesn't have to do that. So UBO has other criteria and stuff they have to file with the FTC for the organization. So there's a bunch of requirements to it that are much higher, much more burdensome, much more a higher hurdle, higher barrier for other promoters. So there's a lot more the UBO is required to do than you would see for any of the other traditional promoters.
Is a UBO really just an alternative to the traditional Ali Act?
Well, this is, as you said, it's a Trojan horse. It's the whole thing. It seems like they're trying to sneak it into the bill to get the UBOs in with all these other portions of the bill to mask it. But I like to steal what Zach Arnold said. It's not an alternative or even an option. The phrase everybody uses, it's an option. Fighters just have options. But Zach Arnold said this, and I agree 100%. It's a waiver, right? Would it be smart to allow people to waive the right for to go to work at a place that exempt from following labor laws? Would it be right to let people say, hey, we're going to give you an option. You can either buy the car that has to follow all the minimum requirements, safety requirements that we have for cars, or you can get the car that's allowed to ignore all of them. Now, a lot of people seeing the price, seeing you getting paid more, or seeing the price of the product might say, you know what, it's worth the risk. But as a public, as a society, we don't let people make those individual choices because it can come back to haunt society. And I think in many ways, the UBO is like that. It's not an alternative. It's a way to sneak in. It's a way to introduce this waiver so fighters are not protected by the Ali Act, right? So fighters can be that they can potentially coerce them and use the UFC model, which again, we should note, we don't have to go back to the IBC of New York. Judge Boulware brought up the IBC of New York case when talking about how the UFC is a monopoly, how their practices of controlling the titles, of demanding fighters sign long-term contracts to fight. All these things we talked about previously, how this created a monopoly. And so I think when we say, is it an alternative? No, it's a waiver to let the UFC practice in a way that we've seen allows them to attain a lot of power and leverage over their fighters.
Do the other protections of the Ali Act apply to a UBO?
I mean, this is worth noting is that it's one thing to say we're going to introduce this alternate system. The other thing is saying we are asking you to waive all your protections under the Ali Act. And so where the UBO says that you are considered in compliance to the act, well, I'm not an attorney. I mean, you've listened to this whole show. Hopefully you listened to our program before and you've heard me put that disclaimer out there. But if you've gotten this far in the first time, let me know I am not an attorney. But we have had attorneys on the show. I've talked to them, many of them, not just, we had Kurt Emhoff on the show, who represents an attorney, represents boxers. That's the interpretation he noted, is that the UBO allows you to ignore the rest of the provisions in the Ali Act. Rob Macy has said that. I've heard him say that and see that on Twitter and say it. We had Pat English, another legendary boxing promoter, bring that fact up. And so I believe Lou DiBella agreed to that too, confirmed that. So many guys with the high, Ivy League degrees or, knowledgeable as attorneys have confirmed to us that that's the interpretation you should take from the bill because it gives a carve out. And so fighters in this UBO, yes, they would gain all those enhanced benefits, right? All those benefits that they said, extra insurance, more ambulances, all those things, but they'd be waiving their right to have the right to private action. They'd be waiving their right for disclosure. They'd be waiving their right to have mandatories, waiving the right to protections against coercive contracts. All these things, as we noted, lead to less competitive markets. At least that was the intent of the bill, and that's the history of the bill shows that in the past, that's what happened. And so they're asking fighters to waive those rights. And so you lose all the protections. So it'd be one thing if the bill said we're going to introduce this new system, but still keep the other protections of the Ali Act in place, that fighters are still protected by them. But no, instead they're asking for fighters to waive those rights to take part in this organization.
Are there other reasons we should be suspicious of the intent behind this bill?
Well, I mean, we've laid out some, but yes, there's a lot of reasons to be suspicious. The first one is we're suspicious because it seems obvious that TKO are the ones that wrote the bill. Before the end of last year, beginning of this year, it was TKO executives that brought up the possibility that the Ali Act would be amended. The bill itself, as you look at the UBO, seems written specifically to benefit one company, right? The other promotions, and we should note, the other major promoters, Eddie Hearn, Oscar De La Hoya out there, Bob Arum, they are against this bill. Well, if this bill was great, any promoter could take advantage of it and create their own UBO. You would think some of them would be excited about that, but instead they want to stick to the current system. Well, the current system has tons of problems, as we noted, and the current system probably needs to be fixed a little bit. There should be some measure of regulation applied to certain aspects of boxing right now. It definitely needs something done. But this UBO, none of them want it. Why? Because they see it applies specifically to TKO. It's a means to get away from the other sanction organizations, a means to not have competition. You should note, TKO Zuffa Boxing is part of the TKO umbrella. TKO has the UFC. The UBO requires that all boxers in the UBO have drug testing. Well, UFC already has a drug testing plan in place. It'd be relatively affordable, cheap for them to also extend that drug testing regime to include the Zuffa Boxing fighters. So that's a cost that's cheaper for them than for other promoters. In addition, the UBO requires that there's additional insurance for injury outside the match during training. Well, that's a policy the UFC currently has. So it would be cheaper, I should say, not cheap, but cheaper for the Zuffa Boxing to enroll their boxers into the same policy with UFC because they have a larger pool. And so the cost wouldn't be as outrageous for them. Will be a high cost for other boxing promoters, who I should note have much smaller margins. So these additional costs become, much more difficult, much harder for them to bear than for the UFC, who, I should say TKO, who has vast resources from the WWE and UFC. In addition, their partners, the Saudis, are going to be picking up the cost, and they have guaranteed revenue already. And so these additional costs are not much of a concern to them, where for another promoter who has very thin margins, this might prove to be too expensive. Finally, it requires you to have some sort of training facility and therapy facility. Doesn't really explain what that's supposed to be, how big, but the UFC has the performance institutes that meet that requirement. And so this is a cost that Zuffa Boxing, who could send their Zuffa boxers to the performance institutes that the UFC has, and be in compliance for the Unified Boxing Organization, that the other promoters do not have. So you look at that and it becomes obvious that not only have they designed a bill that allows them to engage in the practices that they do in the UFC, that the Ali Act and regulation in boxing has prevented. Now they're writing up a bill that does a carve out, but they're doing it in such a way that the expenses for anybody else to create this unified boxing organization are too large. The hurdle's too high for them to also follow the same path, or at least do it as easily as Zuffa Boxing will be able to do. So you look at that and you just can't help but acknowledge that this bill seems almost too clearly specifically designed for Zuffa Boxing or TKO, and that you just can't deny that. So yes, as we noted, it's good. There's many reasons, and that's probably the number one reason why we should be suspicious of the intent behind this bill.
What is your worst case scenario if UBOs are allowed?
Well, my worst case scenario is, and this is something I think a lot of people in boxing are not taking serious yet, would be the monopolization of the sport. And here's a quote I'll give you, and this is hearsay. This is what someone told me. Ari Emanuel once said, and I wasn't in the room, so what do I know for sure? But I do work. I did used to work next to the William Morris Endeavor building, and I'd meet people from that agency and from CAA as well. And one time, someone told me that Ari supposedly said something along the lines of, the problem with boxing is that boxers get 70% and the promoters or us get 30%. And for me, at the time, I guess they were thinking about getting boxing. This is when Zuffa Boxing was launching. I needed to be 30% for them and 70% for me. Now, that's me paraphrasing. Who knows exactly? But would we be surprised if he said that? I don't think so. And so my worst scenario is they've found a way to make this happen. We are in a situation right now where boxing is in serious trouble. The promoters have done this to themselves. The sanctioning organizations haven't helped. But a lot of the promoters are on shaky legs. They're all been Pied Piper off to DAZN. They're all dependent on the partners to the UFC Saudi Arabia for the money they make. They're losing a lot of their boxers that are being signed away from those promoters to individual deals with the Saudis themselves. So the conditions of boxing are not strong. And now you have the UFC come in, I should say UFC, TKO come in with Zuffa Boxing. And if they get this passed and have a UFC model, then potentially we could see what we saw in MMA, where instead of a competitive market, which was the hope of the Ali Act originally, that the market would get more competitive. But that part we did see, the boxing market got more competitive, but what we did miss was it did not get more meritocratic and more objective. That part was lacking. But here we get a situation where the UFC could operate the way they do. TKO, I should note again, could operate the way UFC does and have a title, use coercive contracts, and at first using Saudi money or their money from their other entities that have monopoly rent, sign fighters to very lucrative deals. The very best fighters, get them in the Zuffa Boxing organization. And then when other fighters wanted to fight them, because the way combat sports works, you got to move up the rankings. You got to fight the top fighters for the fans to acknowledge you, and then you can make more money. Well, if all the top fighters are signed to Zuffa Boxing, then you'll be compelled to sign with them, and there's no violation of coercive contracts. And so they can demand that you sign long-term agreements to enter Zuffa Boxing in the first place. They can demand that you will sign long-term extensions to fight for the belt. They control the rankings. So your ascension up the sport is not meritocratic. It's dictated by, do you comply with their demands? That is my worst case scenario, where, we, instead of fixing the problems of boxing and fixing the problems in MMA, we have now just, because boxing has some problems, it has now just gone all the way to the other side and just adopted the problems of MMA, where one entity controls the sport, has a monopoly, and is able to pay much less to the fighters than what the fighters probably generate based on their marginal revenue product, what they themselves are responsible for. And so that would be my worst case scenario, that the TKO in Zuffa Boxing, with the powers that TKO has, with their powers, the influence and the wealth that the Saudis have, although maybe that's drying up, but they still have some money. But they've also managed to, like I said, Pied Piper all the promotions into a barn they can lock the door and let in fire. That together they can get a system where the top fighters are signed to Zuffa Boxing, and then going forward, all the other fighters feel compelled to sign with them, just like what happened with the IBC of New York, just like the Ali Act discussed in the 90s before the passage about how promoters use their coercive contracts to monopolize weight divisions. That would be my worst case scenario, and it seems plausible to me.
What are you hoping the outcome is, to put a pin in this episode?
Well, I'm hoping that there is some pushback by the Democrats. There seems to be little interest in MMA and combat and boxing and combat sports overall, except for a handful of fighters, a handful of members of Congress. Very few people in Congress that I'm aware of are fans of combat sports. It's in the past, you had people like John McCain and others that were very much into the sport and had an interest in it. Here, less so. So I'm hoping that perhaps there's some secret fans, some people that have an interest in this, because without that interest, I know there's been no media coverage. So hopefully there'll be some media coverage and some pushback by those that realize what's happening. If that happens, maybe the bill can be defeated. I doubt the Republicans are going to stop it. So that means the House of Representatives, it'll probably be voted for. Although, maybe a handful of Republicans cross the line, but right now it's a bipartisan bill, so you'd have to get more Democrats to vote against it. So the House of Representatives might be a lost cause, but maybe we're lucky and people become aware of the various aspects of the bill and what's being intended here. But if not, at least the awareness, hopefully there's some sort of, greater scrutiny by those interested in labor law, interested in antitrust, interested in corporate cronyism, because it's pretty obvious that's what we're seeing here. And that will compel the Senate to vote against it. So the hope is that they vote against it. But a greater hope would be, even against defeating this bill, which I don't like, would be to amend the Ali Act to pass a better bill. Now, we had a better bill that's been introduced. John McCain introduced the Professional Boxing Amendment Act. Dust that off and bring it back. That would be great. That would address a lot of the problems that we see in boxing, address a lot of problems of sanctioning organizations. That would be a great step forward. Not that far. I would not be upset if the provisions that we talked about that we liked in this bill were passed, but maybe marry that with the Professional Boxing Amendment Act, marry it with something else to address the sanction organizations, go back to the findings of the Ali Act, go back to the stuff that we know is a problem with the bill. Coming out of the Ali Act, they talked about the problem is not enough disclosure to the public and the fighters, that the ranking organizations are not objective enough in their ratings, and even now the common complaint is that we do not get the right fights because people are not rated properly and get mandatories. There's not enough co-promotion today is often a complaint. Well, this bill makes a lot of those problems worse instead of addressing them. This current bill, I should say. So we should do bills that address them. Go back and introduce a bill, which the Professional Boxing Amendment Act would do, which would bring about greater disclosure to the fighters, make sure they're informed earlier in the process, so they should negotiate better. Make sure the rankings are objective. And the attorney generals at the time suggested that there should be a universal ranking that's written by the Boxing Writers Association, kind of like what college football at the time was. That would be a huge step forward. It would probably put a lot of the sanction organizations out of business, which a lot of people wouldn't complain about. So all that would be great. And the big, the top, the pots of gold at the end of the rainbow that people have been asking for forever, the holy grail for boxing for years, has been a pension fund. And this does not introduce that. So that would be great as well. So something I would love for Congress to get involved, because as the original legislation said, the original Ali Act, Congress is responsible for boxing because boxing is incapable of reforming, of policing itself. And so I'd like Congress to step in and do something, but I believe it should be do something to address the problems of boxing and create a competitive market. I don't believe it should be we're going to hand it all to another company so they can monopolize this as well. And I should note too, it is worth noting, as Pat English did, that as much as TKO might hype this bill on the phone calls to the California Athletic Commission, they are not proposing this bill be expanded to include MMA. So, if all these changes are so great, why don't they want MMA included in the bill? Well, my guess is because they don't want to be one step closer to MMA be covered if it ever goes back to the previous bill. So, so what I'm hoping for is eventually that, people's eyes are opened, and this bill, which I personally do not like, gets blocked, but I would like to see Congress, Senate do something on the boxing end. And we've had proposals before that are much better than this, much more serious. And I'd hope they would dust those off and relook at those.
And on that fine note, that's going to wrap up this extra long episode. Do me a favor, follow John on all of his social media. He is Hey Not the Face on Twitter, Blue Sky, and YouTube. And he is Hey Not the Face podcast on Threads. You can find me, Crooklyn MMA, on Twitter, Crooklyn on Blue Sky, and Crooklyn949 on Threads and Instagram. If you have questions, comments, suggestions, or information, please send them our way, and we will do our very best to feature them on a future episode. From here, y'all know the drill. Until next time, please subscribe, and please stay safe.
Ow! Ow! Not the face! Ooh! Okay, the face!